Hi, I'm Greg McIntyre with McIntyre Elder Law, and I'm here with fellow attorney Jane Dearwester in our firm. Hey, Jane.
Hello there. Hello from Hendersonville.
Our topic today is electronic documents, specifically our eDocs access system, and a discussion of security surrounding electronic documents, the validity of electronic or copies, facsimiles of electronic or of estate planning documents, and how that could affect your ability to probate a will, to use a power of attorney, and sharing those documents with family members as needed, or other third parties like banks and doctors. So that's a little outline of what we're going to talk about today. And there's some interesting discussion to be had around this topic. The world, Jane, has trended toward electronic communication. I wrote you a letter a week ago. Have you received it yet? I wrote it pen and ink and I sent it to you.
Absolutely not. I'll probably get it next month.
I folded it up, I licked it, closed it. And I have this ring. Okay, it's like a Game of Thrones or something. Yeah.
Yes.
And I do them late at night. Like I get up
did you like burn the wax?
I go to sleep when the sun goes down, and then I get up in the middle of the night. It's called just second, and then I'd have my second sleep after that, right?
Yes.
But I get up in the middle of the night, and that's really when I do my business. And I burn a candle. I drip that wax. It's a red candle onto the envelope, and then I seal it and close it, and then I put it in the mail to people.
Yes.
So have you received that yet?
No, like I said, to get to Hendersonville from Charlotte, it'll probably take a month.
A month? So, okay.
I don't have that yet.
Well, oddly enough, I probably sent you 10 emails already today, and you instantly received them. Okay. So the world is trending. I'm being facetious in that discussion, right?
Yes.
Although there is historical fact and interest on how people used to sleep and get up in the middle of the night and do their business by candlelight. And then they'd have what's called the second sleep. And they'd also put letters in the mail, and they'd send them by courier or, mail carrier, right? And it took a while to get there. But the world has changed.
I was going to say, I had to actually remind our litigation team, this is on topic, but a little off the side, that they were trying to get a hold of a client. They said, I've called, I've emailed, I cannot get in touch with this client. I said, send them a letter. They said, you mean like in the mail? I said,
what kind of?
Yeah, like in the mail, like old boomer time, right?
Like actually,
we can communicate.
Type a letter, I will sign it, and we will put it in the mail to this person, right?
But anyone under 40 might not think that that's an actual way that we communicate, because it seems antiquated.
It seems antiquated. The world changes and shifts over time, right?
Yeah.
Very few people actually eliminate all electronic devices in incandescent light and go to sleep when the sun goes down, and then get up in the middle of the night for their business or whatever they need to do, and then get their second sleep, right? But that is an old school way that Google second sleep. You'll see that that is how we used to operate as human beings before the advent of incandescent light. But the world has changed, and to say that, if you're not really familiar with old school letter writing, there's a whole formal process for letter writing. There really is. There's a format. There's a way you do it. There's an eloquence to it.
Yes.
The way people used to, be able to really articulate their thoughts. I think it's a lost art, and I think it's kind of sad
that's what I was thinking too, that even attorneys do less and less written correspondence. Just in the course of my legal career, which is just over 20 years, I used to get a lot more attorney letters, like pen and ink letters in the mail, whereas now it is 90% of my communications with opposing counsel are done via email or text message. And it's, when you get a letter from another attorney, something's up, because they're reducing this to a written letter. That means there's a problem.
The time to do it.
There's a problem. Yes, there's something going on, something serious.
But I would say in our business, if you're not familiar with that, or if you're not an attorney, I preach this all the time in our firm. you know, if you're around me, is, you know, have you sent them a letter? Have we followed that verbal communication up in writing for the record? You know, it's
Yes.
a great thing to have for the record.
Yeah.
So we do that. In addition, I think the law is changing. It has over the years surrounding electronic signatures on documents, which is really the focus of our conversation today, are the electronic versions of the documents.
Mm-hmm.
But, you know, electronic signature, when I think of that, Jane, I think of eDocs. Not eDocs. What's it called when the e-sign, right?
DocuSign.
DocuSign. Yeah.
DocuSign, or realtors call it Dotloop when you're exchanging.
They have Dotloop, there's eSign,
Yeah.
there's DocuSign, there's all these different versions of those programs out there, or different providers. But essentially they're getting your geographic location. I know I've subpoenaed that information for when someone was arguing that they did not sign a document. And I said, okay, we think you did. Our client thinks you did.
Right.
So you can pull that information, and it's unreal how much information they have about that signing. It's arguable that that is more valid than a pen and ink signature. Arguable from the standpoint of, in that case, I had a report from like DocuSign, okay, or one of those systems, and it had the geographic, like within a few feet of where that person was standing when they signed that document. And it was their house. Okay. It was that person's house. So it's kind of hard to argue. It wasn't me. It was like, who else?
So somebody in your house got access to your email.
It was like somebody who lived alone. It's like, did somebody break in your house and hack into your computer and e-sign this document? And why would they do that? Right. So it gets really hard when you pin somebody down to that. And, you know, they had signed it, you know, using their name, right, and typing it in. Now it's easier to even get someone, if they use or prove it was you. And there might be really reasons why you would want to prove it was you. You wouldn't want to get off the hook for that. You want to say, hey, I signed this document, you know?
Yes.
So with something like an iPad and an Apple Pencil, right, I can sign my actual signature electronically on this glass pad, right?
Yep.
It's not a piece of paper, but there's a representation of a piece of paper, a document underneath, and I sign this, and it's got the location where I signed it, the date I signed it's automatically recorded, and it's my actual pen and ink signature, at least an electronic version of that.
Yeah.
You could really argue that that is much more proof and substantial than someone pulling out a pen and a piece of paper.
Yeah.
Because of the other electronic evidence that surrounds the signing of it this way. Maybe it gets a little murky.
It's more just, it's he said, she said. You're like, hey, I signed it.
You can trace it, the IP address, the computer that was used, the device that was used, things like that, right? All that data is there. You don't have that other metadata,
right?
With an electron, with an old school pen and ink signature, right?
Yes.
So, you know, obviously I've thought about this a bit, and I've been down this road before. And, you know, I think there's a lot of arguments to move toward more electronic means of doing things because of that other metadata.
Yeah.
But I do
really, the pandemic really pushed all of us, whether we wanted to or not, into that electronic and digital zone, because it was a weird time and we weren't getting together like we usually were, doing business like we usually were. And so that was the way that we continue to do business and that we continue to practice law. We even appeared in court virtually and signed court pleadings virtually. I mean, all these things have.
Well, why wouldn't a viewing of someone signing a will on an electronic communication like we're on right now, and recording that video like we are right now, especially with an electronic device where they can actually sign it and the metadata is there, wouldn't that be much more substantial than a wedding signature with two witnesses, line of sight, and a notary? And your notary can view electronically too. But, you know, there are, I think the law is slow to catch up with those things.
Of course.
Very slow.
Of course. Well, and we just got a notification beginning of this week that the e-notary statute has been renewed. It expired. It was kind of tacked on to
Not
another
shocking
business.
for me. I don't think it'll ever go away. They still call it the emergency notary,
Right.
where you can do electronic notarization, and there's an additional notarial page, or at least different language with an electronic notary versus a traditional notary. But it's where a traditional notary can view something through what I argue is simply a digital window, right? I have
And
a
they
digital
have to
window
have
into your office. Yeah.
an additional, my understanding, I need to renew my notary as a matter of fact, but my understanding is for e-notary, the notaries have to have an additional level of certification. That's just not the base level. They have to take an extra course or have extra training to be able to do e-notary. And there are steps involved. And in our practice in elder law estate planning, it can be vital to have that option because someone could be, in a facility or in a very remote place where there's not time to get to them or get a notary to them physically.
Can the law, can government keep up with the changing demands of society and the available technology to meet those demands? And I think that's the lag time.
Yeah. There's always going to be a lag
part of
time
that.
because of the process.
The biggest issue is a lack of understanding, general electronic IQ, so to speak, of technology. Okay. And
well, that was on full display when lawyers had to
how
learn.
comfortable they are with it, the people that are making those regulations. So
that was on full display when attorneys had to learn how to do virtual court. So the attorneys that were like, 50, 60 and over, they didn't like it because they had to learn something.
I've argued against it.
They didn't like it.
If I'm in the room with you, it's a lot different than if I'm on.
It is different.
Right.
Fundamentally
different. And I'm able to fully communicate. Plus with neurolinguistics, like non-verbal communication, which is like 93% of how we communicate.
Yeah.
I would say a lot is lost in communication over an electronic format, right? But as far as seeing your signature, I don't know. I guess there could be arguments made that you don't know who's. And my issue with court and having a witness on a stand is I don't know who's on the other side of that computer. I don't know who's on the other side of that screen. I don't know what other computer they've got popped up and documents that are helping with their testimony.
Right.
Those are the issues that I have with electronic court and witnesses and the sanctity of a courtroom and keeping those things, ensuring truthful testimony that isn't coerced or assisted. Right. Yeah. But as far as electronic documents go, I think we've been ahead of the curve. I've tried to use technology where it's useful, and old school. I'll tell you, I have so many people that come in with documents that are just in their hands, or they're in folders or manila envelopes or shoebox, or they're just all over the place. They're disorganized. The documents are. And I hate that.
Yeah.
I think they're so important because I know that you need an original will, pen and ink signature to submit to the court to be able to probate it. And you, not only you, but as the client, but your loved ones who might, your executor, if you die, your agent under a power of attorney, if you become incompetent or incapacitated, need to know, number one, that you have it.
Yes.
Number two, where it is. And if they find it, is it going to be a jumbled mess of poo that they have to sort through to try to figure it out? Right.
Yep.
So,
they're like, it's in the drawer. Oh yeah. With your grocery list.
Which drawer? Yeah. In your drawer.
Yeah. It's in the drawer.
Yeah. I mean, I prefer an organized estate planning binder where things are separated. I think you writing personally some directions and maybe, list of assets, passwords, things like that are smart.
Those are so important. And having it all in a place that's very identifiable, these binders that we provide to our clients, not only do they look nice and look very official, but they really do serve a very practical purpose.
Yes, they do. It's organization, and
Absolutely.
it's ensuring that, you're not spilling coffee and tea on it and the cat's not,
Right.
tearing it up or whatever,
Right.
I mean,
Yeah.
I'd say that, but I have seen messes of estate planning documents before.
Oh, yes.
I mean, things that like rats had gone through and everything else.
Right.
Like I've had to go wash my hands multiple times during an inspection to get a case together. And, for my health and safety and sanity, please organize your estate planning documents and keep them organized. And for yours, right? Just protection of the documents. And then we go a step further in providing technology called eDocs Access. And that's a system that is a bank level encrypted security system. The reason I say that is there's actually a bank level standard, encrypted security system standard. It meets and exceeds that. That's why I went with that system and why I use that term, because that is a known term, that bank level encrypted security level. That is where it meets. And it's the HTTPS connection that is a secure connection, not just an HTTP on a web address connection. And that system is designed to have fraud protections in it if somebody's trying to get in and get your documents, to keep them out. And to allow you to set up a secure password where we scan and put your estate planning documents. So that binder right there in the originals, there will be a mirror of that in the legal work we do for you in that system. And you as the client receive an email that says, to set up your password.
Yeah.
I don't know your password. Nobody in our office knows your password.
Right.
We have the ability to get it on the back end and reset your password for you, or allow you to reset it. But you set up your password. So it could be a husband and a wife that set up the same or separate passwords.
Yeah.
And Jane, you were mentioning you might want to publish your estate planning documents to a family member, maybe your executor, your power of attorney, your agent under a power of attorney in healthcare and financial. Why might that be important that they be able to have access to those?
Yeah. Something happens to you, right? Where you're incapacitated, you're not in a position to give them the information, then they can act as your agent. Or if you pass away, again, if they live out of state or out of the country, they don't have to come and look for your black binder. They just click on to the documents. And we've had clients give incredible feedback of how convenient and grateful they are for that service, especially here in Hendersonville. We have a lot of retirees. This is a huge retirement community, and a lot of our clients' loved ones, they don't live in Hendersonville. Mom and dad or grandma and grandpa live here, but they live in New York, Ohio, California, Florida. They live elsewhere. So it's not so easy to just pop over and grab the binder. That eDocs access can really be a lifesaver. And, that said too, we have clients here in Hendersonville who don't specifically ask, do not put my documents. I don't want
You
them.
might not want a loved one who's receiving assets to know what your
They don't even want them digitized. They don't
true.
want the access. They don't want
We
eDocs.
respect that. We respect that.
I tell them all the time, I say, hey, you don't have to. We don't have to do it, but it comes with our services. But
let's say
I
I have a son and a daughter, and little Susie, she's a doctor, and she's great, she's smart, and she's my healthcare agent. And little Johnny, he's an accountant, and he's gonna, he does a great job managing money, and he's going to be my agent under a general durable power of attorney for financial and legal purposes. And they're both co-executors on my will. I love them. I trust them. I want to share that with them. In our system, we would just simply send an email to each one of them where they set up their individual passwords and have access, right? With your consent, with the client consent, right? I would have to consent to do that and ask to do that, right?
Yeah.
But we present that option.
Yeah. Like I said, for the majority of people really, really appreciate that. And then there's a minority who says, nope, I just want the real thing. That's it. And so, of course, that's the client's choice.
Sure. Well, it's important that you do have the originals.
Yes.
But if I'm traveling, there might be a time where I need a healthcare power of attorney for my wife, or that she needs one for me. And I'm not lugging my estate planning binder along with me. Right. So therefore, she can log on right on her phone even and show that, or download it, email it. You send it to whatever entity needs it. If it's a hospital, at the beach, if it's a financial institution, right? You can manage those things electronically, and that's the point.
Yeah.
So let's say you lose the originals. I think that's another reason why that's super powerful. As long as the power of attorney is recorded at the Register of Deeds, number one, it's there. That's an electronic copy that the government has. The government has.
And if you need it to be more official, you can get a certified recorded copy. You can go physically to the Register of Deeds and give me a certified copy of it. If you lose the original, at least you got a certified copy.
There's a statute in North Carolina essentially that says an electronic document that's, signed, a contract, an estate planning document like that is as good as the original.
Yeah.
So for powers of attorney, that's great. Where we run into trouble is with trying to probate a copy of a will.
Yes.
It's assumed, there's a presumption that you revoke the will if somebody shows up at the courthouse after you die with a copy trying to probate it. It's presumed that you decided, hey, I want to destroy this original. I've changed my mind. And then you might have heirs out there that have a copy and then try to probate it. So there's a presumption that you have to overcome, and it's a high bar. There's certain elements you have to prove. I've done it. I've had those hearings to prove that. And, you have to get over that bar and have quite a bit of evidence to be able to show that the will was simply lost and it was unintentional, right?
Yep.
But at least that's another safeguard that if you did lose your original, that there'd be a place to go to get a copy.
Yeah.
Right?
That can be huge, right? That can be.
It could be huge. It could be the difference between
absolutely
your will standing and passing assets or not being able to do that, right?
Yeah.
So it is a safeguard. So electronic documents and copies of those, there's people who come down on both sides of that argument, but we think it's extremely important to offer that option of storage of those. And we do that free of charge for life for our clients. And can't overstress the power, the importance of keeping the originals also, but the times they are a changing, and that will always be true, right?
Yeah,
so
always.
We have to change with it as a government. The government has to change, the laws have to change, and we as attorneys have to change. And at our firm, we aim to stay a step ahead. That's all we got to be, Jane, is a half step ahead.
That's right. It's the way to be.
So anyway, thank you, Jane, for discussing this interesting topic with me.
Yes. Thank you.
Absolutely. And we'll see you next time on our Elder Law Report.
All right.